Good morning and welcome to the Florida Supreme Court. The first case on our docket this morning will be Desai versus Lawnwood Medical Center.
Good morning, Your Honors, and may it please the Court. My name is Richard Levenstein. I represent Dr. Anil Desai in this case and in a companion case involving a physician by the name of Dr. I.
Could you speak up a little bit?
I'm sorry.
Sorry.
I'm Richard Levenstein. I represent Dr. Anil Desai in this case, and I also represent Dr. Basil Keller in a companion case that has been stayed in the 4th District Court of Appeal as a result of the exercise of this court's jurisdiction. This case comes to this court on the basis of the court's conflict jurisdiction. Dr. Desai asked that this court not allow him to be deprived of his right to seek judicial review of the denial and termination of his medical staff privileges at Lawnwood Regional Medical Center, which he held for almost 20 years, by virtue of a unilaterally created and imposed administrative process imposed upon him by the hospital, to which he neither consented, agreed in any way, or was bound by legislation or the Medical Staff Bylaws, which this court and other courts in this state have uniformly held to be a contract between the members of the medical staff and its membership when executed by both parties.
Would you explain the basis for this court's jurisdiction?
Yes, sir. This decision of the 4th District Court of Appeals conflicts with the Florida High School versus Melbourne decision, the NCA versus Brinkworth decision, and this court's decision in Seeger versus Lawnwood Regional Medical Center. Those first two cases involved the imposition of an administrative process upon members of those associations pursuant to the bylaws of the organizations to which they were voluntarily members. The third case, the Seeger case...
But aren't those contexts entirely different? I mean, well...
They're not. They're different in the sense that they're different facts and different contexts, but the principle is the same. In those cases, those members agreed to be bound by those bylaws that provided administrative processes to which they were required to comply in order to seek judicial relief. In the Seeger case, the hospital governance law was struck down as unconstitutional by this court as a unilateral amendment and impairment of the medical staff bylaws. Section 6 of that law contained an administrative process which the board had created as part of that statute that was far less restrictive than the board's fair hearing and appellate review process that is the subject of this case. In both cases, this is nothing more than an impermissible unilateral amendment of the medical staff bylaws, contrary to its terms, contrary to the Florida statutes, and contrary to the holding in this case that the framework of self-governance created by Chapter 395 of the Florida statutes and the medical staff bylaws was completely interrupted and destroyed as a result of the enactment of that statute. In this case, the board's unilateral imposition and creation of the so-called fair hearing and appellate review process does exactly the same thing as was prohibited in the Seeger decision. I hope that answers the question, Your Honor. In this particular case, Dr. Desai was a longtime member of the medical staff of the hospital practicing pathology. In December of 2009, the hospital terminated his medical staff privileges and denied his reappointment after the Recredentials Committee and the Medical Executive Committee had given him favorable, unanimous recommendations for recredentialing. At that time, he was invited to a meeting of the Board of Trustees, and the timetable in this case is important. The Medical Executive Committee met on the evening of December the 6th, and on December the 7th, the NEC met the next morning. The Board of Trustees met the very next morning at 7 a.m. Their lawyers put on a PowerPoint presentation and in effect held a trial with regard to Dr. Desai's medical staff privileges, and Dr. Desai was present but was not permitted to fully participate in the meeting and had only been invited to the meeting a week before with no notice of what was going to take place. This is the morning after the Medical Executive Committee had unanimously approved his medical staff privileges and re-credentialing. His re-credentialing was denied, therefore terminating his privileges. The Board of Trustees notified him on the following day or two, and at that time, for the first time, provided him with the Board of Trustees' so-called fair hearing and appellate review procedures. Dr. Desai never consented to be bound by those procedures. A review of the applications that he submitted for medical staff membership.
Let me ask you this,
Yes,
Mr.
yes,
Levenstein.
yes, ma'am.
Under the bylaws of the hospital, I guess you have the medical staff has its bylaws and the governing board has its bylaws. Is that correct?
Yes, ma'am.
Okay. And under those bylaws, well, the medical staff's bylaws and the statute, I guess that's what, 395?
Yes, ma'am.
The medical staff has the duty of peer review. Is that correct?
Yes, ma'am.
And does the medical staff have the obligation to lay out the procedures for that peer review, or who has that right?
In looking at the Florida Administrative Code, there are two provisions that are applicable in the particular section, which is 59A-3.272. Section 2 deals with the board's bylaws and what is to be contained in those bylaws. Section 3 deals with the medical staff bylaws. The medical staff bylaws must be approved by both the medical staff leadership and the medical staff members and the Board of Governors, in this case the Board of Trustees of the hospital. It is the joint obligation of those parties to comply with Chapter 395 and the Joint Commission's requirement for accreditation in terms of what's contained in the medical staff bylaws. The statutory framework lays out the peer review process is in the purview and jurisdiction of the medical staff in Chapter 395 because only physicians can conduct peer review. The Board of Trustees is given the ultimate authority to review and make decisions based upon recommendations of the Medical Executive Committee, the elected body that is the leadership.
What is that guided by? If the board has the review of what the medical staff recommends, what are they guided by?
They're guided in this case by a provision in the bylaws that states, and as was provided for and held in the Seeger case, that on matters of medical staff matters, the board shall not unreasonably withhold its consent and ratification of decisions and recommendations of the medical staff, and those decisions are made by its leadership, which is the Medical Executive Committee. So there's a limit on the authority that the Board of Governors can execute in accepting
So
or
in
rejecting.
this case, okay, if there are, I assume there are 4 or 5 different things that the board can look at to say, even though you said this person should be recredentialed, we're looking at this and he fails in this particular area. What was the problem with Mr. Desai?
Okay. In this case, the board took the position that there were issues with Dr. Desai's review of certain slides as a pathologist and other issues with regard to his work that had been performed. They had created 9 issues that
Let me ask you this, were those things also looked at by the medical staff?
They were looked at by the Credentials Committee, the Medical Executive Committee, and both bodies found that there was no merit to the issues that the board had brought. And the board brought those issues to the Credentialing Committee during the meeting of the Credentialing Committee, immediately before it, not through the corrective action procedure of the medical staff bylaws, which lays out when there is a complaint against a physician, how they are to be brought to the attention of the medical staff for processing and review.
Couldn't Dr. Desai have challenged the basis for the board's decision in an administrative hearing that's provided for in the fair hearing and appellate
He was
review
not that,
process?
I'm sorry, I didn't mean to interrupt. He was not required to do that.
But he could have.
If he chose to, he certainly could have, but that process has
He
no...
applied for readmission in September 2009, is that correct?
I'm sorry, I didn't...
He applied for readmission in September of 2009, is that correct?
I believe he submitted his application for recredentialing within the time frame, which I believe was in September of 2009.
And that was 2 years after the board adopted its fair hearing and appellate review procedures?
That was 2 years after the date of that process, yes, sir.
And in applying, didn't he file an undertaking and affirmation in which he agreed to be bound by those procedures that had been adopted 2 years earlier?
No, sir, he did not. That application process refers to the hospital's bylaws, the medical staff bylaws, and the rules and regulations of the medical staff.
I thought you conceded in briefing that he had agreed to be bound. You just said that at some other point he said that he protested.
Oh, no, sir, we did not agree to that. And we did not stipulate that he agreed to be bound to these procedures. If that was the case, then we would have totally different arguments in our briefs, and I'd be arguing a different case today. We never have agreed that these procedures were binding upon Dr. Desai. And in further answer to your question, Justice Lawson, Dr. Desai's process that the board attempted to impose upon him has no safeguards, has no due process, and is at the complete control of the Board of Trustees.
I mean, I don't have the record in front of me, but the notes I have say that at record 4031, there is a document that's called Applicant's Undertaking and Affirmation, and it provides that Desai agreed to the procedures defined in the Medical Staff Bylaws.
That he did.
Okay,
I'm sorry.
Okay, go ahead.
These procedures are not in the bylaws. That is the gist of part of our argument. These procedures were unilaterally created by the board. They are not in the bylaws of the medical staff. They are not in the bylaws of the hospital. They are not in the medical staff's rules and regulations. Those are what Dr. Desai agreed to be bound by in that application process. This is a standalone document entitled Board of Trustees Fair Hearing and Appellate Review Proceedings.
So did you establish that the first time that he was aware of these procedures was after he was denied his, what do you call it?
His recredentialing, Your Honor.
Recredential, by the board that which you said was at the time of the hearing?
Yes, ma'am. He received this process for the first time after the denial of his recredentialing. These documents were never provided to the medical staff.
But just going back to fairness, because that's we get past jurisdiction. Fairness is sort of always what we're concerned about. What Justice Lawson asked you is, why wouldn't the administrative route be a good route, exhausted, and then go and file your lawsuit?
I'll be happy to answer that, Your Honor. This process is at the complete control of the Board of Trustees. There is no input from the medical staff from the very beginning of the action, in which it states that the conduct of the hearing will be at the choice of the trustees.
It's not a standard. It's not like going to an administrative hearing through the administrative law judge.
No, ma'am.
Okay, so we're talking about an internal
A
administrative
complete internal process, which is in stark contrast to Article 8 of the Medical Staff Bylaws, which was agreed upon by the medical staff and the trustees.
But if he went through that and it was denied, could he then have filed his lawsuit?
He could have. It would have cost him another year in terms of time, at least thousands of dollars in additional expenses, and the overwhelming chances would have been that the result would have been the same, and he would have come to court with another decision against him to overcome, because this process was designed not for the benefit of the practitioner, but for the benefit of the governing body.
Let me ask you this, because I want to make sure. Go ahead.
In the bylaws of the medical staff,
Yes.
is there a procedure for this kind of situation when a physician has been denied recredentialing?
There is a bylaws procedure when the medical executive committee has taken an adverse action against a practitioner, meaning a denial of application or reapplication or recredentialing.
But that's when the medical
Yes,
staff
ma'am.
actually
Yes,
does
ma'am.
it. Does it cover when the governing trustee body
Governing board, right?
does that?
There's no specific, the only procedure that addresses that is a joint conference committee when there is a difference of opinion on a medical staff matter between the governing board and the medical staff. Now, these bylaws were created in 1993 and are still in existence. They're the same bylaws as the court addressed in 2008 in the Seeger case. These bylaws had not contained and do not contain a fair hearing and review procedure with regard to the adverse action of the board specifically, but that's because the governing body never came to the medical staff to have a discussion about it, and instead, from 1993 to 2007, operating under bylaws as they were, and not coincidentally, a month after the First District Court of Appeals decision striking down the governance law, which included Section 6's appellate procedures in that statute, only then was this process, which we're here about, created.
Well, let me
Counsel-
ask you one further,
Go ahead.
one further question on that. So what happened prior to the board passing this procedure? What happened in a situation where a doctor was denied credentialing?
They went to court and filed an action because there was no further administrative process to exhaust.
Counsel, you have now used some of your
I have.
rebuttal time. Do you wish to reserve? You may,
I
or
do.
you may go
I do.
forward.
Thank you.
Richard.
May it please the court, my name is Tom Warner with the law firm of Carlton Fields. With me today is my partner, Dean Morandi. We are representing Hospital Corporation of America in this particular case. We covered a lot of ground there, but I'd like you to read, the first question is, did the medical staff and Dr. Desai agree to be bound by these particular procedures? And I would point you to, interestingly enough, a provision in the medical staff bylaws, and that would be Section 2, undertaking. And what it says is, every application for staff appointment shall be signed by the applicant and shall contain the applicant's, quote, subparagraph D, statement that he/she has received and read a copy of such hospital and medical staff bylaws, rules, and regulations in force at the time of his application, and that he has agreed to be bound by the terms thereof in all matters relating to consideration of his application without regard to whether or not he has granted appointment to the medical staff or not. So there's an express provision in the medical staff bylaws.
So are you equating then the hospital bylaws with the board bylaws? I mean, because you said that says the hospital bylaws and the medical staff bylaws. So
Correct.
you are equating hospital bylaws with the board bylaws.
That is correct, because that's what it says, such hospital and medical staff bylaws. So, in fact, directly in, and that's under a section called undertaking, there's a direct provision that you are presumed to read them and agree to them when you apply for your privileges.
And
in fact,
when was that, and that was signed by Dr. Desai, you
Right,
said, and then
and-
what's the date of that?
I don't remember the date, to be honest with you, but he did sign a document that was called an oath or an affirmation, I think, that he did. Now, he made a notation that he was signing under protest, but if you look at the notation, it's not having anything to do with the issues in this case. He just says the form wasn't approved by the medical staff, but in fact, that was the form that was being used by the hospital for everybody, and that's what he signed, and he didn't, and when he signed it, he agreed to be bound as he stated in order for
And
him
that
to-
was the September 2009 document that,
What's that?
that was the September 2009 document?
I believe that's right. That is absolutely correct.
So was the fair procedure, whatever we're calling this, was that written in what he signed? Was it attached to the bylaws? I guess what I'm trying to understand is this sounds like, and I realize we got a record so we can figure this out. It sounds like it was a standalone procedure that had been created after Seeger to give the hospital exactly what was held to be unconstitutional in Seeger, which was virtual control over the decision whether to recredential doctors.
This is nothing like Steger. In this particular case, the hospital's provisions in regard to this appellate review and administrative hearing does not change one word of the medical staff bylaws. It doesn't add anything, it doesn't subtract anything, it doesn't do anything of substance, procedurally or otherwise, to the rights under the medical staff bylaws. What happens here, the role of the medical staff and the medical staff bylaws is to evaluate, it provides a procedure and criteria to evaluate applications for credentials to the hospital. The medical staff processes that along with the applicable forms, and they eventually make a recommendation to the Board of Governors, the Board of Trustees of the hospital, as to whether credentials should be granted or denied. At that point, the decision is then the hospital's decision, the hospital board's decision. And all we're saying here is that when, according to the law, Florida law, the hospital is required at that point to provide an administrative process and appeal if, in fact, they deny the privileges. And that no way conflicts with anything in the medical staff bylaws, does not detract from any rights, it doesn't change anything whatsoever.
Now, under what authorities, either a statute or a rule or something, does the board have the authority to promulgate procedures for peer review and medical staff privileges, those kinds of issues? I thought that those were issues that were left to the medical staff group, and so what statute or rule gives that authority to the board?
Okay. Chapter 395 and rule of Florida Administrative Code 59A-3.272. That particular rule is entitled Hospital Licensure and Governing Body, and it goes through all the various powers and duties of the hospital board to essentially run the hospital. And that particular rule says that the governing body, it all has to do with the governing body to organize the hospital under written laws, rules, and regulations, to state the purpose of the hospital, provide for officers and directors, coordinate an executive committee, establish a position of chief executive officer or similar position, and provide for the responsibility and authority and accountability of the chief executive order. And then the next provision in this same rule pertaining to the powers and duties of the governing board says the governing board shall approve the bylaws and regulations of the organized medical staff, comma, provide for the appointment, reappointment, dismissal, or members of the organized medical staff, comma, and provide for a procedure for hearing and appeals on all actions concerning appointment, reappointment, or dismissal. And then under subparagraph 4G of this same rule that has to do with the powers and duties of the hospital governing body, it states The governing body shall establish a procedure for an applicant for privileges to appeal an adverse decision and shall establish the timeline for a time-limited period for rendering its final decision. So Chapter 395 and this administrative code provision imposes a duty on the board to implement an appeals process if the board rules unfavorably to the applicant.
Without input from the medical staff.
Well, it's.
I mean, that's really their, sort of the essence of this. If you have a governing board that is at odds with its medical staff, and somehow Lawnwood, seems to have been involved in a lot of litigation on this issue, that the staff should have an input in what the peer review procedures would be.
Well, the governing board is ultimately responsible for what happens in the hospital and how the hospital is governed. There are areas where the hospital and the medical staff are presumed to work together on those areas.
Sure, but we're really talking about this type of situation where a doctor is saying that, and I'm not, again, not looking at all the pleadings, whether this was a political thing, they're saying it was a competence thing, I assume, and clearly there would be situations where the staff might protect its own, and therefore you need a objective review. So I guess the only question I have on that is you saying that those procedures that exist in Lawnwood, first of all, are they typical hospital procedures and they don't have to be agreed to by the medical staff? So two things. Is this like a standard type of review? And two, is it understood that the medical staff does not get to participate in the type of review procedure given?
Well, I think the point that I would first like to make is that the role of the medical staff and the medical staff bylaws is that it provides a process and the criteria for granting or denying privileges in the hospital. And there's a whole sections of provisions of the medical staff bylaws that go through that procedure and how it is particularly done. It culminates with a recommendation by the medical staff to the Board of Trustees as to whether credentials should be granted or denied. At that point, the role of the medical staff under the medical staff bylaws is at an end. And it is now the board's decision, one way or the other, to grant privileges. The law says, both Chapter 395 and this Florida Administrative Code provision says, if the hospital at that point decides adversely against the applicant, it must provide for an administrative proceeding and appeal in order to give them to challenge it. And if you look at Chapter 395, it makes sense because the whole basis of this, and including what you call the cooperative government agreement, is that these matters are supposed to be left up to the hospitals and the medical staff, not in court to argue about the rights and wrongs of it. And yes, you're right. Attached to the complaint are various documents which outline that the hospital had serious concerns about Dr. Desai's competence in practicing, including he was a pathologist, the question of misdiagnosis of cancer in a particular patient, a misdiagnosis of leukemia, failure to adequately produce reports. So there was a serious question here, at least in the Board of Trustees' mind, as to whether they should grant privileges or not. But the point is, once the medical staff makes its recommendation, then it is a board decision, and it's the board decision, it's the board that has to provide a vehicle for that doctor in order to challenge it. Now,
Let me ask you a question about the procedure that was adopted. It's my understanding that there would be a hearing before a neutral decision maker, and that decision maker under the procedure adopted by the board would be jointly agreed to by the doctor who's challenging the decision and by the board. Is that correct?
Right. As a matter of fact, I was just getting to that point.
Okay.
These
And
procedures.
I guess my other question is, they haven't complained about the person who would be selected because
Well,
it
they
would be a
never
joint
have
decision.
been selected.
And I didn't see where there was any complaint about anything about the procedure process that would tend to make it unfair. The only complaint was that we should have agreed to it and we didn't agree to the structure.
Yeah.
Is that right?
That is correct. That is absolutely correct. And I think on pages 8 and 9 of our brief, we outlined some of the procedures. And as you correctly pointed, that the aggrieved physician is entitled to a hearing before a mutually acceptable arbiter, hearing officer, or panel of 3 individuals not in competition with Desai. Full rights to produce witnesses, cross-examine witnesses. There's never been any challenge to the fact that this is somehow unfair or unusual. And as a matter of fact, the standard of review is whether or not the board's decision was unreasonable or without good cause or contrary, not supported by the substantial competent evidence. So it's a very liberal review standard for the doctor to challenge the action of the board, and it had full guarantees of rights to produce witnesses, to produce documents, to have a full hearing on these matters. So there's nothing in here to indicate that the procedures that were adopted were somehow unfair or tilted against the doctor.
Mr. Warner, as this thing is unraveled, it seems to me we're coming down to the point of contention is that the doctor is asserting that the medical staff needed to approve the process, and the hospital's view is based upon the statutes and the administrative rules that is not a requirement. Is that a fair statement of what this dispute is really about?
Well, there's probably more to it than
Well,
that,
but I mean, we're not here.
I will accept what you said.
We're not here fighting about the facts of the case. We're
Right.
talking about the hearing process.
Correct.
And you rely on 395 and the administrative rules. Am I understanding that correctly?
Correct.
And what is your understanding of why the doctor is saying that's a wrong interpretation? What is your, how would you word what their challenge really is here?
Well, I think their position is that everything has to be in the medical staff bylaws. And our
Okay.
position is that once the medical staff makes its recommendation to the board under the medical staff bylaws or otherwise, its role then is at an end, that at that point it is the responsibility and the duty of the hospital board to make the final decision. And-
Under the procedures that are established.
What's that?
Under the procedures that are
Right.
established. And that's the
Well, no,
point.
That's under the medical staff bylaws. Medical staff bylaws say the board has the final decision making. And so our point is that once you get to that point, the medical staff's role is at an end. And it's the board that makes a decision. It's the board that's required by law to provide an administrative process to challenge that decision if it's adverse to the doctor.
And you made the very pointed comment initially that this is not like Seeger at all.
It
Tell us why.
Okay. Well, first, and I have that here. First, in this particular case, there is nothing that the board has done in writing or otherwise that contradicts, eliminates, changes, deletes any provision of the medical staff bylaws or any of its processes. There's nothing that by implication repeals or changes anything in the medical staff bylaws. They are intact, and that's what they do. Now, in Steger, Steger was a comprehensive law that covered virtually every aspect of the relationship between the hospital and the medical staff, and gave the hospital almost absolute power to delete things, change things, ignore things, whatever they wanted. For instance, Section 1 and 5 provide the hospital with a complete override of any medical staff bylaws in the event of a conflict with the bylaws. The override extends not just to peer review, but also to bylaws involving medical staff privileges, quality assurance, and contracts for hospital-based services. It gave the board the right to unilaterally amend the medical staff bylaws, something it could not do before enactment. The rights granted to Lawnwood in sections 1 and 5 relating to hospital-based services are also a significant feature of the hospital governance law. And I could go on and on and on, but I'm reading from the opinion in Seeger at page 516. It goes on for another page outlining all the multitude of areas of substance that the hospital governance law allowed the hospital absolute control over. It has nothing to do with what we're doing here. We haven't changed one word of the medical staff bylaws. We haven't done anything to substantively or procedurally interfere. It is a duty under the statute for the hospital to provide this avenue, this administrative remedy, if you will.
Wasn't the issue, the legal issue that was decided in Seeger, whether the special law provided a privilege to a private corporation in violation of the Florida Constitution?
Yes, I mean, if you get down to the barest of bones, Steger is also not like this, because the issue in Steger was the constitutionality of a special law that was found to provide a special privilege to one corporation out of all the corporations out there in the state of Florida. So one corporation had this absolute power to do what it wanted. In this particular case, the Florida statutes and the Florida Administrative Code state that all hospitals must provide an administrative review process if their decision is adverse to the doctor. I just have one other comment, and that is I guess I'm not going to have much time for one other comment, but the NCAA case and the Florida High School Activities Association case are nothing like this case. In those cases, they do stand for the proposition if you're going to participate in an organization, you are bound by the rules of that particular organization. But in both of those cases, it was athletes, a student athlete in high school, a student athlete in college, that had been declared ineligible by the NCAA and then Florida High School Activities Association. And those students sued in court to try to get their eligibility back. And their cases were dismissed because there was an administrative remedy available to them by the NCAA and by the Florida High School Activities Association. So they were thrown out of court for not pursuing their administrative remedies. They weren't members of the organization. They were high school athletes that were participating. And so the proposition is, if you're going to participate, you must play by the rules and abide by the rules. Thank you.
I will give you an additional minute,
Thank you, Your Honor.
in addition to the 3 minutes and 45 seconds.
Thank you. I'll be quick. With regard to the fair hearing and appellate review procedure, if you look at the process, it does not provide for the choice of an arbitrator. It provides that the board shall determine whether an arbitrator mutually acceptable to the individual and the trustees, a hearing officer appointed by the trustees, or a panel of individuals appointed by the trustees shall preside. So the board makes the choice as to who's going to preside, and if the parties can't agree, the board then takes the other two alternatives at its right, and it controls who will hear the matter. And in reviewing this process, it changes the burden of proof. In other words, a physician under these processes goes through a favorable process of the Credentials Committee, the Medical Executive Committee, and after the board decision, he then has or she has the burden of proof to show why the decision of the board following those two favorable recommendations is incorrect.
Well, let me ask you this. Mr. Warner just said that under 395 that the governing board, is that the proper term, is given the authority to make these kinds of appeal procedures.
That he was.
What is your interpretation of that 395
I believe he was
provision?
referring to 59A 3.272 section,
I'm sorry, he was referring to what?
the Florida Administrative Code 59A.
I thought he said chapter 395.
395 just lays out the requirement for a medical staff bylaws procedure to contain the peer review process, the credentialing process, and the recredentialing process. Part of the recredentialing process is the board's ultimate decision and what follows. The medical staff's role doesn't end there. If it did, this court would not have ruled as it did in Seeger when it found as to Section 6 of the governance law, which provided a procedure similarly to this one, a unilaterally created appellate process where the board's decision was adverse to the practitioner, was a unilateral amendment of the bylaws.
But
and
my
was
question,
impermissible.
though, is this: who has the authority under 395, Rule 59, whatever, whether it's a rule or a statute, who has the ultimate authority to make procedures for review of any decision of the governing board?
It's a joint responsibility of the medical staff and the governing
And
body
that-
to do so.
And that it can be found where?
If you look at section 59A-3.272, section 3, dealing with what is contained and what is to be contained in the medical staff bylaws. And if you look to chapter 395.0191 and 0193, which lays out the delegation of the responsibility for peer review as a condition of licensure and continued licensure for a hospital, and for joint commission accreditation, as this court held in the Seeger case, the medical staff bylaws have to contain those procedures. This was a unilaterally created process with no participation from the medical staff. If the medical staff had participated, the process would have looked much more like Article 8 of the medical staff bylaws, in which the members of the medical staff participate in the process. They each name 7 members of the hearing panel, and then those 14 name the 15th. The medical staff member participates from start to finish, and a hearing officer, a truly independent hearing officer, is appointed. If this process had been a jointly agreed upon process and a fair process, that's what it would have looked like. And if this process can be imposed upon a physician without that physician consenting, and I will refer Justice Lawson you back to this application and undertaking, nowhere in what doctor agreed upon to be bound by is there a reference to a fair hearing and appellate review procedure or any procedure. What he agreed to be bound by were the hospital bylaws, the medical staff bylaws, and the rules and regulations of the medical staff and directives of the medical staff. This document, the fair hearing and appellate review process, is none of those. And in fact, it even states in its text that when it is inconsistent with the hospital bylaws, that the provisions of the fair hearing and appellate review procedure will control. So it's clearly not anywhere in the
Your time
bylaws.
has now expired.
Thank you.
Thank you both for your arguments.
Thank you.